So welcome. My name is Joe Rufino. I'm going to be introducing today's speakers. I know you're here to see me. No, you're here to see them. And so I'm going to get started. September is Wills Month in Mexico. It's a time when legal professionals typically discount their rates for preparing wills. While many people don't think about the end of life planning, it gives people peace of mind, help them avoid probate, and protect their heirs from having more to deal with than the emotionality of a loss. Today's lawyers, Mariana Salas and Ana Andrade, thank you, of ProLegal San Miguel will explain the Mexican will process and answer general questions about wills in Mexico. They have about 2 decades of experience handling wide variety of legal situations in San Miguel. So please help me welcome to the podium Mariana and Ana.
No, I think it's just better.
Fine like that? Okay.
I have my coffee.
Okay.
Good morning, everyone. I hope you hear me well there. Yes?
So the people on Zoom can hear you.
Okay, right there. Okay. Well, always a pleasure. Thank you very much for having us today. Not only that, the library brings a lot of beautiful memories as a San Miguelense, so it's always so nice to be here. Um, well, we know you have a lot in your minds, but we came prepared with the most common questions we receive in our practice. However, of course, we're here to solve as many questions as possible, and hopefully we can meet your expectations today. I'm not certain if it's 2 decades already, but probably we're heading there. And then I met, yes, many, many years ago, 19 years ago. Now, and we have been working together almost 15 years now. Um, and as part of our practice, we have been dealing with, of course, estate planning in different areas and for different individuals. And hopefully, we can share with you today what the experience has brought to us. So I'm going to start with the main question we receive all the time. People regularly comes to our offices and they ask, well, first, what happens if I die and I don't have a last will and testament in Mexico? Well, there are different rumors about that, and people often believes that if you die in Mexico without a last will and testament, your property would automatically go to the Mexican government. But you need to know that if you die in Mexico without a last will and testament, of course, there is a process that the law protects, and your next of kin is able to carry out a probate in order to prove that they are the heirs and therefore entitled to receive the assets that you have in Mexico. What I want to convey with this is for people without a last will and testament in Mexico and not being able to do the arrangements, just know that there is a specific process that protects your assets in Mexico. Those would not be taken away immediately by the Mexican government. I think that's very important to clarify because we hear this a lot. And in the event that you have a last will and testament abroad, meaning the United States, Canada, or any other country, that last will and testament may be used in Mexico. Requirements need to be fulfilled, of course, because you would need to have that, well, your heirs in this case would need to have the document duly apostilled and translated, but the document will be completely valid in Mexico. We have had these cases before, and fortunately, we have never encountered any problem by making that last will and testament effective in Mexico. So the answer to this question, what if I die in Mexico without a last will and testament, would be if you have a last will and testament abroad, that is completely valid. And If you don't have any last will and testament, then your next of kin or your beneficiaries would have to go through a probate in Mexico. That would be the immediate answer for that. So I just don't know if we're going to have questions in between or just see, see. I think so, no? So
Now, we had some questions that came in online. You can see those.
yes, and I replied those, but I'm happy to discuss that too.
Would you
Yeah.
like to do that first and then wait?
I think that can go at the end because those questions, yes,
Okay.
are not
Okay.
related to.
Anybody got any questions?
If you have an American will and a trust agreement, will those be valid in Mexico?
Yes. The answer is yes, both of them. Last will and testament and trust. A trust has the treatment as a legal entity, and same thing, the trust would have to be notarized, apostille, and is completely valid in Mexico. That's a very important question because also, before going to that question, I just want to go through this very quickly. We often receive this question too. People wants to know if the assets they have in Mexico may be inherited to a trust in the United States. And the answer is yes. Of course, because a trust is considered a persona in terms of our law, a legal entity, and a legal entity is able to receive assets without any inconvenience. Honestly, I don't know where the myth comes when we hear this as a negative. You know, people would say, "Oh, I heard I'm not able to transfer this my asset in Mexico to a U.S. trust," but the legal answer is yes. You may. Hmm. Yes.
Yes, I have a question. I know legal gay marriage is legal in Mexico, but I just want to double check that my husband will be my heir, and also, how many death certificates would I need? Could you guess?
Yes. Okay, to confirm effectively, your spouse would be able to inherit without questioning anything. You just have to have a valid marriage certificate. Whether being in Mexico or the United States or any other country, provided that is a marriage certificate issued by an authority is completely valid in Mexico. And we regularly advise people to have, well, I would say five additional death certificates would be good to have. You know how things work in Mexico. We just love paper.
My question is, we have a will in Mexico, which is a Mexican will, and we also have one in the United States.
Hmm.
So which are do we is it necessary to have a will in Mexico as well, or what should we do?
See, and that's a very good question. That's another question that I have as the most frequently asked questions. Um, my answer to this question all the time is yes, and the reason is the process. Uh-huh. Um, if you have a last will and testament in Mexico and you have a last will and testament in the United States, and your last will and testament in the United States mentions the property in Mexico, however, that last will and testament does not contradict your last will and testament in Mexico, uh-huh, and your heirs only make your last will and testament in Mexico valid, then the process is quite simple. From beginning to end, 3 months before a notary public, very inexpensive from my point of view because your heirs, if they are spouses or children, only get to pay 0.5% of the fiscal value of your property and notary fees. So it's very inexpensive just to complete the process, easy to do. So my recommendation is yes, have a last will and testament in Mexico just to make things much easier for your heirs. Hmm.
Yes, two questions. Um, is if you're a Mexican citizen, is the development or the makeup of a will differ from a will from an expat? Question number one. Two, if I'm an expat
Mm-hmm.
and if my beneficiary lives in the United States, if I were to die, will she need an apostille to present to the government?
Yes. I mean, documents must be apostille to be completely valid in Mexico. So if it's issued by an authority, only apostille is required. If it's a private document, it has to be notarized in that country and then apostille. Yes.
Hi, Mariana. David, how you doing?
Hi, David.
Um, a few years ago, I'm sure you remember, maybe 5 or 6 years ago, a woman left property in El Centro.
See, I know what you're
Remember?
talking about.
Right. There were 4 houses, and as I recollect, you'd know better, they were left in the name of the University of Guanajuato, correct? And somehow, I don't know what happened, the properties ended up in the hands of individuals.
Mm-hmm.
Could you clarify that? I was always curious how that happened.
Mm-hmm. Well, to the best of my knowledge. So when let me try to simplify this because my legal mind came just. In terms of our law, we have something that we call vacant assets, bienes vacantes, no, o mostrencos, dependiendo. I'm sorry because I have to think in Spanish about that. But basically, what happened is, in terms of the civil code of the state of Guanajuato, the law establishes if no one claims an inheritance and after exhausting a legal process, the University of Guanajuato may acquire those assets. The University of Guanajuato, in this case, went through the legal process to prove that there was no other people interested in acquiring the assets, meaning beneficiaries, heirs, or creditors that may acquire these properties by means of the last will and testament, by means of a payment. And the University of Guanajuato, after going through this process, proved that they were entitled to receive the property of this woman. So legally, those properties were transferred to the University of Guanajuato, and by means of an agreement of the board of the university, they agreed to sell the property rather than use the property as we were hearing that they were going to use the property for their own facilities, and they end up selling those to different individuals. It was highly criticized in the university and by prior directors of the university. However, that didn't stop the former rector of the Universidad de Guanajuato to just they just sold the properties, but not that the property, not that the university. This is just what happened. They inherited because those assets had no heirs, and then the university sold them. That's what we know that happened. Sí, claro.
Yes. So I have two questions.
Te dejo ahí.
First off, if you have let's say not a marriage in itself, so I have a wife and we have a domestic partnership. Will that be enough for a will to be exercised, or do we need to get married? And let's say in Mexico, we both are Mexicans and U.S. citizens as well. But then, what will be the best structure to have? Is that enough? I mean, the domestic partnership in U.S., or do you need to come here to Mexico and get a married licensed per se? So that's my first question.
Okay, this question has different answers. The First of all, if you just mention her name in the last will and testament, that would be sufficient for her to receive your assets without any inconvenience. The big difference is taxes. Mhm.
Exactly.
So when you have an inheritance and that inheritance goes to spouses or children or from children to parents, then again you only get to pay 0.5%, provided that they are residents in the country. If they are not residents in the country, is 25% of fiscal value plus 5% of what we know as impuesto cedular. So a total of 30% of the fiscal value. So most people decide to formalize the situation just to avoid paying taxes. However, note that in some cases, when we say 30%, people goes like, oh my God, and I know it's a lot, right? It's 30%. But when we calculate it, sometimes it's not that much. And then people going through the entire process of formalizing a relationship or trying to get married in Mexico, becoming a resident, end up spending more than just paying the actual tax. So something just to consider when you are doing your estate planning, how much it would cost will depend on the current value of your property. So the immediate answer would be if you mention her name in the last will and testament, that would be sufficient for her to receive the assets without any inconvenience. Now, in terms of the figures, law recognizes two different figures. For the state of Guanajuato, something that we know as concubinato. And you are able to record your concubinato in the state of Guanajuato, meaning that you have been living with that person as spouses for more than 5 years. And in Mexico City, they have something that is known as Ley de Convivencia, where you are able to register the name of somebody else just as your partner of life, and they receive the same treatment. Of course, formality is always the choice. It's always the best from my point of view. But if you have any impediment, just to formalize as a concubinato or as an spouse your relationship, just make sure that your last will and testament and any other documents related to last will and testament as bank accounts, insurance, investments have the name as appears in her passport or any other identification.
Thank you.
You're
And the
welcome.
second one is what would be best or more advisable to have a figure here in Mexico as an equivalent of a trust instead of just passing the assets to a person?
That would really depend again on your estate planning, but I would say trust is advisable when you have several assets that people will still be receiving benefits from. So let's say you have 5 houses and then you want one of the houses to be sold, the other one to be continue rented, the other one to be preserved as a local place for people to visit because you have a beautiful garden. That would be the purpose of having a fideicomiso, because outside the áreas restringidas, meaning outside borders in the ocean, ocean areas, a trust in Mexico, its management may go from 60,000 to 100,000 pesos a year. So that would be $5,000, correct? A year, just for the bank, just for the fiduciary institution to manage it. So that may come expensive. See? Well,
My question's a little similar. When we first came to San Miguel, the house was in my name solely. When I wanted to add my partner to it, there was a huge fee of like a gift. I had to gift half of the house to him, and we had to pay tax on that gift. Okay, which we did. but now we own another house in joint tenancy.
Mm-hmm.
If I pass, are we going to go through the same thing with I have to gift half of the house to him, or is it that 0.5%?
See, so if the property is 50-50 or any other percentage, but both of your names appear in the title deed, when one of you predeceases the other, you have to go through the process of acquiring the share of the person that predeceased you.
So it's actually more expensive if you're on joint tenancy with two people rather than just having sole tenancy and to inherit it.
It may, yes, but again, it really depends on your estate planning, because if you are not planning to sell the property ever, my advice to people is just, well, keep it in one of your names so you don't have to go through the process when one of you dies. However, people sometimes want the possibility to sell the property, and capital gains tax comes just beneficial when you have two people included in your title deed or more, because everyone gets an exemption, a separate exemption, even when it's just one sale. So it's just a matter of revising what is that you would like to do. But I mean, again, if you get to sell the property, then you duplicate your capital gains exemption, which is a great benefit. We're talking about 320,000 US dollars per person approximately. But if one of you dies, the other one has to go through the process of getting the other percentage. But again, it's 0.5%. So it's not, it's not that much. What we have been seeing lately, I would say, is going around 30 to 50,000 pesos, you would say, Anna? Uh-huh. So it's not really that, but including taxes. Mm-hmm. Just to pass your percentage to somebody else. Mm-hmm. Because even properties in Centro are the value of those are not considered very high. As you know, we will calculate it based on your property taxes statement, the predial. Yeah.
My question is, my husband has a visa, and I have a residente permanente.
Mm-hmm.
Should he die first, and although our house is in his name,
Mm-hmm.
is that a problem, or should we change that?
No, because then if he dies before you, you just get the property in your name if he never changed his will. We don't know, but it will come according to his last will and testament. And you, as a permanent resident, you only get to pay that small percentage, and provided that you have your marriage certificate here in Mexico. That's very important for you to always have available here. Marriage certificate, birth certificates, all of that has to be apostille.
Two questions, one very quick. I just want to confirm something you said.
Yes.
So the properties, when they pass from one person to another, are not assessed at fair market value. They're assessed at basically the assessed value for taxes, correct?
Correct.
Okay. Is there pre-death planning that people should be doing in terms of having paperwork in order? You mentioned having marriage certificates, having, I don't know what else, like what documentation aside from Mexican wills would we want to have in place if we live in Mexico?
Well, I would like to have Anna complimenting that, because she's the one who's very well organized. A ver, te dejo, Ana.
Hola, buenas tardes, yeah, maybe, I don't know. So, yeah, it's a very important question, and it's very important because we will not just drop death like that, right? There are certain documents that we may have in order, and even after we die, so that our beneficiaries or the executor appointed have handy, and they don't, go crazy trying to gather documents. My suggestion is, let's think of it as now we are alive, we are owners of a property, like in many cases here, with our husband or with a daughter, or I don't know. So have a power of attorney. It's always very important, because if something happens to you that do not take you to death, but you're incapable or you are sick and something needs to be done with your property, then you want to have someone represent your interests. So important to have a power of attorney. Additional to that, very important too, to have an advance directive, which we call also living will, in case we have a difficult death or a process of dying. So we can convey what we want for that situation in terms of our health, our treatment, psychologically, and so you have hospice and all that, and you can include that in your living will. And also after that, of course, the will. And in the will, it's in the will, you can establish many things. We can also establish moral dispositions, although I have to say that most of the notaries I know prefer that you have those moral dispositions or instructions to your family in a different document. Some notaries say a will deals with property, not with the person. So even your funeral arrangements, you can include it in your will generally, but you can also have a set of instructions to your beneficiaries or your beloved ones that will remain and take care of your matters. So that instructions will be helpful. It would also be helpful to have a document establishing your additional assets, not only your property, your real estate, but also other property that you may not have in Mexico, but in the United States. Some people add passwords and, personal identification numbers to the accounts because there may be the need of having access to those properties by your beneficiary. And although it shouldn't be this way, Mariana have mentioned also before, like when someone dies, there are immediate expenses that maybe you can just withdraw the money if you have the opportunity, because otherwise it will take a while. Besides those, there are personal documents that you may have with you that will help the executor, which is a copy of your birth certificate, your social security number, because that will be requested by the consulate to file for the CRODA, information about the domestic help that you have, because one of the credits to the state is the severance to employees. So if you don't have a record, if you don't have a contract, then it will be hard to calculate how much they are entitled to receive as severance. And I would suggest, because I have gone through times or processes when people die and the person remaining, we don't have information on who you want to be informed about your demise. There have been cases when someone dies and we don't have the contact of their sisters or so. Leaving a list of contact information for people that was or is important to you would be very helpful. Mhm. Copy of your passport and resident card, that will also be necessary. Yes. Mhm. Thank you.
Hola, soy Patricia. We have a joint testament made in Denmark and registered in the embassy in Denmark. But this joint testament in Mexico is not possible to have it. Is going to be valid?
See, well, my immediate answer would be yes, provided that fulfills the formalities, meaning that the heir is duly established, that you have an executor appointed, and that your asset is duly described. We were just facing with a situation where the last will and testament was granted in Canada, but the language was different from what it is in Mexico, especially with the executor. It was called the trustee, just very different. And we analyzed the document with the notary, and he considered that because those figures were duly identified, heir, executor, and property, he was able to enforce the last will and testament. But again, just to make things much easier for your heirs, I would definitely suggest for you to grant the last will and testament in Mexico.
Yeah, it's translate and register in the Mexican embassy in Denmark, but in Spanish.
See, and that will be valid then. Yes.
Okay, we
Sí.
have 5 minutes left. Did you want to get
Oh
to
my
the
God.
questions? Yeah, to the questions you got online so we can, because we like to end it on time, but go ahead.
Totally. I will just go very, very quickly through these questions that I already have with me, and then we can just go to the online because I don't want to miss the opportunity because this is a very common question. So people often ask if you are able to include your assets abroad in a Mexican will. Yes, you are, but just make sure that the dispositions here would not contradict the law in your country, and always consult also with an attorney there. A lot of people regularly would just come and leave everything behind and then leave bank accounts or Social Security benefits back in the States, and you need to make sure that your last will and testament in Mexico has the specific language that would be required eventually to make that disposition valid abroad. So always to have somebody else double checking that information for you in your country. And also people ask, if I don't have a real estate in Mexico, should I have a last will and testament just for contents, vehicles, bank accounts? Again, that would really depend on your estate planning. The suggestion is yes, have one just to make sure that your assets will be allocated according to your preferences. But if you know already that your contents will go to a specific people and you have no other assets but just furnishing and some other things that you want to leave just to your loved ones, that may be included in a separate private document, not a formal disposition. Again, that really depends on your estate planning. How much it costs, that's another question we receive, of course, a lot. The notary public is the one that formalizes the last will and testament. And it may go from inexpensive, 3,500 pesos. And you may add 1,000 every time, just depending on the notary, the length of your document. But regularly, I would say a fair price would be average 5,000 pesos. That's what would be a fair price. May I modify or revoke my last will and testament? You may, but you have to grant a last will and testament every time you want to have it modified. So that's why Anna was saying moral dispositions or other type of dispositions just may be included in separate documents, so you don't have to modify your last will and testament every time, and just leave your last will and testament with the main dispositions, so you don't have to pay for one every time. Those, and then thank you. Yeah, so we can go through the other questions. See,
Is it online?
I'll have Anna.
We had one question on Zoom. Do we got it?
Sí. Thank you.
If beneficiaries appear differently on a will than on bank accounts, which one takes precedent?
The immediate answer would be bank accounts first. So, because those are federal laws, whomever that appears there duly identified, and if that identification matches what you have included in your bank accounts, the bank will not request for any other document and they will release the funds. If there is a contradiction, well, that would be a matter of just going through a different process between the people who's trying to get the funds available. But the immediate answer would be first bank accounts, because those are federal laws. And then our law is a local law, so it's underneath the federal laws.
Any other Zoom questions, Diego? One. Okay.
It's the same. It's the same. The difference is the name. We call it in Guanajuato, it's called Advanced Directive, but people know them as Living Will. It's exactly the same. Mhm.
Thank you. We have one more question. If you can please briefly describe the apostille process.
Sure. Just for all of you who are unacquainted with the term, the apostille it's a certification. It's an additional certification that every document that will be used in a different country requires. So if I need to use my birth certificate from Mexico in Canada or in other countries, I need to have an additional certification. The apostille is issued by the State Department of the local government where it was issued. So one from Chicago has to be apostilled for by the Illinois State Department, and so on. Okay.
Thank you both. Mariana, Anna, we always learn so much from you. Thank you so much.